Well, good morning, everyone. Welcome. I'm Jeff Brauch. I'm the Dean of the Law School, and on behalf of the Law School and our Center for Global Justice, it is my pleasure to welcome you here for our third annual symposium for the Center for Global Justice. And I have to tell you, I am very excited about the symposium this year. If you've looked at the topic and the speakers that we have coming from Africa, I think this is going to be a very special time today and tomorrow. When we look around the world, I think it's obvious the more we see all that's taking place in this country and elsewhere, that in order to protect rights around the world or to promote justice, the rule of law is critical. You can have beautiful documents, you can have great commitments, but unless the rule of law is established and takes hold in a nation, you don't have justice. And so my hope and prayer, and I think we've been praying for this as we've been thinking about this and inviting you and praying for your attendance, is that we won't just come together and talk today and tomorrow. This will be a time of fellowship, partnerships that will bear fruit, but that God will use the things that we talk about, the ideas that come from this, to help establish the rule of law, yes, in East Africa, but around the world. And so please join with us as we pray about that and go through this weekend together. It is my pleasure to introduce Jonathan Adams, who will lead us in prayer. I think it's very important that we put God at the center of what we're doing. For this to be productive, God needs to be in it. It can't just be us trying to make something happen. And so we want to begin our time by putting this before the Lord. And I want to just briefly introduce Jonathan. He's the co-lead pastor of the Village Church at Vinings. He is an MDiv from Southern Baptist Theological Seminary. He served with Reach Out Ministries as the short-term missions director to Eastern Europe for 7 years and went on to become the director of student ministry at a local Atlanta church for the following 8 years before planning the Village Church. He's also the director of development for 60 Feet, an organization that we have partnered with and that has hosted interns from Regent, and so a partner that we value very much. And so would you please welcome Jonathan Adams, and he'll begin our time with prayer.
Very much, yes. Let's go to the Lord in prayer. Lord Jesus, we thank you for today. We thank you for giving us life and breath and for allowing us to be here where we can talk about the important things that relate to you and what's on your heart and what's on your mind, and that is people. And so as we talk about East Africa, Lord, I pray that you'll guide our conversations today. Meet with the panelists, speak through them, give them wisdom, help them to say what they wanted to say, and help us all walk away with new knowledge of how we can serve you better as we serve Africa. In Jesus' name, amen.
Again, welcome everyone. My name is Ernie Walton. I'm the Administrative Director of the Center for Global Justice. We're going to get started here with our first panel of the day. If you wouldn't mind, everyone, please make sure your cell phones are on silent at a minimum. You can turn them off, probably even better. And if you have questions, there will be a time towards the end of the program for questions, so please hold your questions if you have any. It is now my privilege to introduce you our first panel moderator. He is a professor at Regent University School of Law and also the executive director of the Center for Global Justice. Please join me in welcoming Professor and Executive Director Craig Stern.
Good morning and welcome. The first panel is Advancing the Rule of Law in East Africa, What, Why, and How. And it features two distinguished guests who will be speaking to us. The first is Professor Cynthia Alcon. Professor Alcon joined the faculty of Texas A&M in 2010. Before that, she taught law at Appalachian School of Law here in Virginia, though I'm not sure I should say here in Virginia, since it's very far from here in Virginia. Before the academy, she was a criminal defense lawyer and worked in the rule of law development in Eastern Europe, Central Asia, focusing on criminal justice reform issues. She was a deputy public defender in Los Angeles, and then she joined the American Bar Association's Central and East European Law Initiative, working as a rule of law liaison in Belarus for 2 years, 98 to 2000. After Belarus, Professor Alkan was head of the legal department for the Organization for Security and Cooperation in Europe, that's the OSCE, in Albania. From 2002 to 2006, Professor Alkan was head of the Rule of Law Unit for the OSCE Office for Democratic Institutions and Human Rights. And in that position, she supervised the Rule of Law Unit's criminal justice reform assistant projects in Central Asia, the Caucasus, and Eastern Europe. Professor Alkan's scholarship focuses on criminal dispute resolution, comparative criminal procedure, and rule of law reform, with particular interest in issues of criminal justice reform, both within the United States and in the context of rule of law reform programs abroad. Professor Alkan is a contributor to indisputably.org, sounds rather authoritative, a member of the Law Professor Blogs Network. Professor Alkan earned her LLM in dispute resolution from the University of Missouri-Columbia, her JD from the University of California, Hastings, and the BA, magna cum laude, in international relations from San Francisco State University. Welcome, Professor Alkan.
So thank you. It's a pleasure to be here, and I'm very much looking forward to the rest of the discussions. What you heard in my introduction was absolutely nothing involving East Africa. I'm looking forward to learning lots from those of you who are from the region, have worked in the region. And my talk, I was asked to talk generally about rule of law, which is something I know a little bit about, and to hopefully start to frame the discussions for today, and hopefully frame some issues to think about, and hopefully to be thinking critically about the work that some of you may do in the future or that you may currently be doing. First of all, we became Texas A&M this year, and we've been asked to use these templates. So there's Texas A&M everywhere. So I'm still getting used to it myself. I hope that it's not too distracting as we go through the PowerPoint. So I was given a list of questions, and the first one is, what is rule of law? And I have like 20, 30 minutes to speak. That alone could take, treatises have been written about this. So what I'm going to try and do as we're talking about it is just give some thoughts that I think will be helpful in framing the discussion. This is not a definitive work on what is the rule of law. Obviously, scholars have many definitions. Like I've said, treatises have been written on it. It's a term that's used frequently without much agreement on what it really means. It's used by politicians, it's used by practitioners, it's used by academics, without often a lot of agreement about what it means. And the reality is practitioners on the ground and politicians spend very little time even trying to define it. We tend to operate from our assumptions of what we think it is and move forward. This quote, the beauty of the rule of law is it's neutral. No one, the human rights community, the business community, the Chinese leadership objects to it, was given by an official of the State Department who was working in China. And it is, no one's ever going to say we don't want rule of law. Right? And so it is one of the realities when folks are out and about doing this kind of work, is it always starts from the discussion being that rule of law is good and we all want rule of law, although we may not all agree on what rule of law is. So I'm giving two definitions. Michelle may have some other thoughts on useful definitions, but the idea here was just to kind of give a couple of definitions that might be helpful in framing our discussions in the next 2 days. So this is a definition that I like, that we actually used as our operating definition when I was head of the Rule of Law Unit for the Office for Democratic Institutions and Human Rights of the OSCE in Warsaw. I liked it because it's simple, which is, and this is from Thomas Carruthers. I think a lot of you are very familiar with his work. He's written quite a bit on rule of law development and democratization work in general. And he says it's a system in which the laws are public knowledge, are clear in meaning, and apply equally to everyone. And I think that's useful because when you're looking at law, obviously it's useful if we're not talking about it applying to just some people. It doesn't just apply to men, it applies to women too, right? It doesn't just apply to those who are powerless, but those who are powerful. It doesn't matter what your ethnic or racial group is, right? Everyone should be operating and operating under, and these laws should be applying to everyone. There's no group that's exempt from the laws in a society. The other definition is a lot more wordy, And I think it's a definition that is in some ways more aspirational. So I'm going to read this. I apologize. I think this is the slide that has the most words, so I apologize for doing this to you. So the rule of law is a system in which the following 4 universal principles are upheld. So the government and its officials and agents, as well as individuals and private entities, are accountable under the law. The laws are clear, publicized, stable, and just, are applied evenly, and protect fundamental rights, including the security of persons and property. The process by which the laws are enacted, administered, and enforced is accessible, fair, and efficient. And finally, that justice is delivered timely by competent, ethical, and independent representatives and neutrals who are of sufficient number, have adequate resources, and reflect the makeup of the communities they serve. Now, this is the definition that the World Justice Project has put together. They do a rule of law index where they're evaluating countries and their level of rule of law. I think if we look critically at our own country here, we can see that we have a ways to go on some of these, right? I've worked in the criminal justice system for a number of years. I certainly have written and have some concerns about a couple of these categories. So this is something that I consider more of an aspirational definition, and certainly something that gives us some frameworks for thinking about how to go about approaching what is rule of law. What's often missing in the definitions of rule of law is something that is not missing in practice in the application of rule of law development projects, which is the importance of attitudes. In order for rule of law to exist, it really relies on individuals within a society voluntarily following the law. Right? You can't have a police person, right? I found a police woman there, I think. I'm not sure. But you can't have a police person standing on every corner all the time, right? People have to decide that they agree with the structures that are in place, and they're going to voluntarily follow the law. They're not going to only follow it when it's going to be enforced. And in order for this to happen, people have to have trust in the system. Social psychologists write a lot about the concept of legitimacy. And it's an important concept for people to agree to voluntarily follow the law. They have to think that the system has legitimacy. And there's a lot of writing about what makes for legitimacy in a legal system, what makes for people both within this country and in other countries have that level of trust in the system so they'll voluntarily agree to follow the law. A lot of rule of law development projects have a component dealing with public attitudes and trying to reach people so they can first understand what the law is, but second of all have some, it's often called buy-in or belief in the law. So it's something that, although it's often absent from definitions about what is the rule of law, is present in practice in rule of law development projects. And I think for those that work on the ground, and Michelle can, has a little bit more recent experience, she can tell me if she thinks it's less so, but I think there's a consciousness of those who are working on the ground of the importance of attitudes in the development of rule of law. But if we don't have a single definition of rule of law, is it important? And so I think we wouldn't all be here today if it wasn't. Right? I think that we all believe that it is, in fact, very important. Without rule of law, everything becomes much more difficult. Life itself in countries that are not defined by rule of law is uncertain. It's difficult, can be dangerous. Economies don't work, right? You need a functioning legal system at least minimal levels for economies to start to work, and you need you need more sophisticated laws to have it work better, right? So in terms of being able to get foreign trade and whatnot, which in our global economy is an important part of making an economy work. And one of the big concerns is if you don't have rule of law, conflicts and day-to-day disputes can very easily inflame into violence. The picture on this slide is from events going on this week in Kiev. This is Ukraine. And so this is a current example of the concern and the problem of what happens when one does not have rule of law or stable rule of law. So I was also asked to talk about what are models for rule of law development. I think of it as two basic models, and I think that the work that goes on around the world kind of falls into these two basic models. The first is a governance model. This is frequent in post-conflict countries such as Bosnia, Kosovo, East Timor. where the international community takes over the governance operations of a country. This can include running legal institutions. In Kosovo, for example, there were European and Americans acting as judges in the legal system. So it involves governance at every level, and having internationals actually doing the governance in the particular country. And within this kind of model, rule of law development is happening. Laws are being written, and legal structures are being improved and developed. But for the focuses of my talk today, this is not where I want to be thinking about, because I think that the questions are necessarily very different when we're looking at a governance model, when the international community has come in, when a country is no longer sovereign. So what I want to focus on is really the second model, which is the assistance model. And this is where a country maintains full sovereignty and accepts rule of law development assistance in a variety of forms. More countries fall into this model, including many post-conflict countries. Afghanistan, for example, falls under this model. Afghanistan remained a fully sovereign country as large amounts of aid have gone into it. And this, like I said, is the model that I really want to focus on as we're thinking about rule of law development. I'll delay that thought for a minute. Okay, so what is rule of law development assistance? What does it look like? Once again, I'm using a framework that Thomas Carruthers put together because I think it's just a simple way of looking at what is rule of law. And he talks about there being a standard menu, which is done more often than not when we're going in and doing rule of law development assistance, which involves reforming institutions, rewriting laws, upgrading the legal profession, and increasing legal access and advocacy. So these four categories that I'm going to talk about. So reforming institutions. This can happen in a variety of ways. We have courts. That's the Supreme Court of Russia. This is a courtroom in Albania. The training of court personnel. This is a training of Armenians, judicial officials. And police, right? It's a training of police that the OSCE did a number of years ago. Prisons, so working and interacting with police and prison institutions can be a part of this. And wrapped up in reforming institutions can be things like technology, court administration projects, things like building courthouses, and I'll talk a little bit later about how some of that can play out. Building other facilities, such as police stations and prisons and whatnot. And then direct monitoring of courts and of human rights can all happen under this general category of assistance. The second broad category, which I think a lot of times is the first thing that people think about when they think about rule of law development work, who have perhaps not done as much of it, is rewriting laws. Let's see, Albanian parliament. There were certainly huge efforts in the immediate post-communist era to help rewrite all the constitutions in the former Soviet Union and the former Yugoslavia. And a number of internationals, including law professors in this country, were very involved in those efforts. But it doesn't just mean constitutions, there's also laws. And in every country where rule of law development is being done, there's usually active projects to reform, rewrite, and do what folks consider to be improvement to the law. And some of this can include adding new concepts such as plea bargaining. A lot of countries, most countries don't have plea bargaining as part of their criminal justice system. I have concerns about that. I'm happy to talk about those later, but there's, so it's not just rewriting, say, a criminal code, but it may include adding new things that have not previously been done, not just kind of firming up the language a little bit. And it can also include things like training for legislative work. So this is a World Bank training for people who are doing legislative assistance work. In the process of writing laws and rewriting laws, I think one of the concerns that I have is that I think that sometimes when internationals go in, there's an assumption that things need to change. So when I got to Albania in 2000, I was informed almost on arrival that the most important issue that the OSCE was working on in Albania was human trafficking. And human trafficking, I saw that your law school is very concerned about this issue. It's an extraordinarily important issue. So, fair enough, right? It's an important issue. Albania is a transit country. Continues to have fairly porous borders. It's pretty easy to get into Albania, and then once you're in Albania, it's pretty easy to get to Europe. You just need to take a speedboat over to Europe, and you're in the EU. So there were concerns, trafficking people, drugs, and guns, but the people were the primary one. And I was informed as the head of the legal department, the priority is you've got to work on reforming the laws in Albania. Because right now there's no law in Albania to prevent human trafficking. And I thought, it's kind of strange. How can there be no law, right? Because what is human trafficking? It's bringing people over borders illegally. There's probably a law against that, right? Forced, sexual enslavement. There's probably a law against sexual assault and a variety of things. There's probably laws against kidnapping. I mean, when you break human trafficking down, it's crimes, right? And Albania had a criminal code. It certainly was not a country without a fully functional criminal code. But the difference was that people hadn't thought of using it in that context. And so the first thing that I did is, with the help of the Albanian lawyers who worked in my department, was we put together a little chart. Here are all the crimes that are involved in human trafficking. Here's the section of the Albanian criminal code that prohibits this. Here's the possible penalty for these offenses. Now, could the law have been better? Yeah. Would it have been easier if there were things like witness protection so that the women who were being trafficked could be protected and not prosecuted in order to then reach people higher up? Of course, there was certainly room for improvement in the law, but there wasn't an absence of law, right? And so, and I think that's one of the important things to keep in mind when talking about writing laws and reforming law. It's important to understand what currently exists and how can it be used. Right? And just because folks have not been thinking about it in a particular way doesn't mean they can't start to. Right? So the second category, upgrading the legal profession, or third category, excuse me, this involves a variety of things. So training programs, feature in almost all these slides, right? This is a mainstay of rule of law development work, lots of training. So this is a training for lawyers. If you look really closely, you can see they're wearing earphones, which means it's happening through translation, which means you've got an international involved in it. This is another training. This was for law students in Kyrgyzstan, working with law faculty. So this is the Sharia law faculty in Kabul, and this is the law faculty in Pristina, in Kosovo, the University of Pristina. So working directly with law faculties on a variety of ways is part of upgrading the legal profession. It can involve changing licensing frameworks or creating frameworks. Sometimes there's not much in the way of a framework for licensing of lawyers. And it can involve technology, both for education and for lawyers who are practicing. And the final category is increasing legal access and advocacy. So one big area that was done in a whole lot of the former communist world was creating ombudsman offices. This is the Croatian Ombudsman Office. That's a model that a lot of Western European countries have adopted and find a lot of value to in terms of protecting human rights, and one that there was a lot of encouragement to develop in a number of the former communist countries. And as part of EU accession and aspirations to become part of the EU, ombudsmen's offices have been very much a part of that. It can involve creating, this is the Ombudsman Office in Georgia. It's called the Public Defender, but it's not. That's the English translation they give, but for our understanding of public defender, which is lawyers who do direct criminal defense, that's not what they're doing. It's an ombudsman office. But it can involve things like creating legal aid networks, legal aid offices, public defender offices, and then as part of this, once again, we got training. Right, this is a training program that was done in Kazakhstan for lawyers in Kazakhstan. So those are kind of the standard menu of what gets done on the ground. I was asked to talk about what are best practices. And once again, this is a topic that we could go on and on with. And the reality is it's difficult to say. In this field, there are very few studies, and there are fewer studies that go over the long haul. The evaluations that tend to be done in rule of law development tend to be done by donors to justify or not getting funding. So evaluations of programs to figure out if USAID should continue funding, for example. So you don't see a lot of outside independent assessments and evaluations. There was a lot of critical looking at the law and development movement. Some of you may be familiar with that. It started perhaps in the 50s, but certainly by the 60s and 70s, and it had to do predominantly a bunch of American law professors thought we can do better, and started working predominantly in Latin America. And by the 70s, most of them were declaring it an abject failure. And there was a lot of very critical writing about law and development and about what had been done and about all the efforts and time that had been put into it. And then a number of years later, people started looking at it again, as there were transitions in Latin America away from military dictatorships and into democracy, and saying, well, maybe it wasn't a complete waste. And so some of the studies that have looked at it again, things like, have looked particularly at countries like Brazil, where a lot of the folks who were very involved as law students in law and development projects became leaders in the new democratic government. But it's hard to know. It's very hard to evaluate, because rule of law development is so very complex, and that's something I'll talk about in a minute. But it really involves every aspect of a society, and so it can be very difficult to measure and figure out what is having an impact or not in this complex environment. And so far, we don't have a real systematic approach to thinking about how do we study this and figure out if what we're doing is making a difference. And most donors tend to think in very short-term increments. If you've got a 5-year project, that's a long project in the rule of law development world. But in terms of developing rule of law, that's a drop in the bucket. Right? We're probably talking about multi-generational work. So I've expressed some concern about what I've called, not too originally, the cookie-cutter approach. And this is the concern that in most countries, rule of law development assistance looks very similar. Despite the fact that conditions and levels of development can be very different, there may be differences in approach. Do we take a bottom-down or a top-up, top-down, bottom-up approach? But the bottom line is, if a country is receiving aid, there is very little discussion about whether rule of law assistance should be part of the overall package or not in that country. And this was something that I've written critically about in the context of Afghanistan, and we'll talk about that in a minute. That we just assumed we were going to be doing rule of law development work in Afghanistan. And remember, Afghanistan, we aren't talking about a governance model, right? This was an assistance model in going into the country. And I think it comes from a very good place, which is the recognition that rule of law matters, and we want other countries and citizens of those countries to enjoy living in a country that has rule of law. So I think it comes from the best of motivations. But I think we sometimes fail to recognize that we can take a different approach. So I think it's one of the ways that can be useful to think about this is taking Maslow's pyramid, right? You may remember from your psychology classes way back in undergrad, right? This idea that we've got a hierarchy of needs, right? And until basic needs are being met, it's hard to get to this higher level that Maslow talked about as self-actualization, right? It's hard to get to that point in individual development. So I think it's useful to think a little bit about development in this context, and these are not hard and fast. I just kind of took some categories off the USAID website, and thinking about what would be basic needs. So things like water, sanitation, agriculture, food security, these are basic needs that can be met through a development program. What might be mid-range? So depending on what kind of health program we're talking about, it might be a basic need, it might be more of a mid-range need. Education programs, improving literacy in the country, things like that. And then we get to things like economic development and trade, right? So there's basic kind of economic development, but then there's more sophisticated levels of it and things that involve trade and international trade. And that, and along with things like gender equality and rule of law development and democratization, these are much more complex forms of aid that are being given and involve a cross-section of societies, usually, in order to have the programs work. And once again, I don't want to suggest that this is a hard and fast, one's at the top and one's at the bottom, but just to get us thinking about this concept. So I was also asked to talk a little bit about what are the factors that can hinder rule of law development. So with this understanding that rule of law development is highly complex, it is one of the most complex forms of aid that we give, what are the things that can stand in the way of it developing? And once again, I want to emphasize these categories are in the context of work that I've done in other parts of the world and my thinking about places like Afghanistan. So I don't know if this applies to individually or collectively to countries in East Africa, but I hope that it can help to give a framework for some thought and some discussion, and you all can let me know whether you think it's relevant to these discussions. So I think there's four factors that I am concerned about can hinder the development rule of law and that demand that we think a little bit more critically about whether we're doing it and how we're doing it. So the first is the level of legal development in a particular country. The second is the level of economic and social development. The third is the level of institutional or political development. And the fourth is whether there's ongoing armed conflict. So in the first one, the level of legal development, one question is, are there laws on the books? Is this a country that has formal legal structures? So I think Michelle can probably talk about this a little bit more from her experiences in Afghanistan, but one of the concerns in Afghanistan when the NATO invasion in 2001 is that it was hard to find the laws. The Taliban leadership thought Sharia law as they interpreted it, and there wasn't a lot on the books. The old laws, it was hard to find even copies of the criminal code when the international community first started working there. That was one of the things that really created some barriers to rule of law development in the country. Do people tend to use informal dispute resolution processes, or are they going through the formal justice system? So are more disputes being taken to village councils, village elders, councils of elders, or are they going to the courts? And in Afghanistan, to this day, I think more disputes, and Michelle, you can correct me if I'm wrong, but I think more disputes are going through informal structures than going through the formal structures. And this can create some issues when we're doing rule of law development work. And one of the little statistics that I found is the United States built about 40 courthouses in Afghanistan, brick and mortar kind of courthouses. In a society that doesn't have a lot of current attitudes of using the formal court system for a variety of reasons. And so a lot of those courthouses have very quickly gone into disrepair and they're not being used. Some of them are in regions, and we'll talk about the influence of armed conflict, it's not so safe, so there's reasons relating to it. So this can be an impact in terms of thinking about, well, what's the level of legal development, and therefore what makes sense to do, right? Does it make sense to build courthouses in a country that's got more informal dispute resolution processes? And what is the state of the legal profession? So in Afghanistan, as late as 2007, there were 236 lawyers in the country. Anyone know what the population of Afghanistan is? Probably about 32 million. Okay, so that's not a lot of lawyers for a country that size. And it's increased when they changed the licensing, and there's also, in addition to that, there's prosecutors. They weren't being counted as lawyers. We can talk, the prosecutors can talk about what they think about that kind of a categorization. Right, they were counted as people, I do believe, yeah. So there are about 2,500 prosecutors in the country, which is also not a lot for 32 million, right? And these are 2007 figures, so I imagine they're a bit different now. So that's thinking about what is the level of legal development. Does it make sense in the particular country to be working, or what kind of projects might make sense given the level of legal development? The second is the level of economic and social development. So what's the level of education? On a good day in Afghanistan, maybe 28% of the population is literate, 30%. The literacy rates for women are far lower. I've seen figures as low as 12%. I don't know if you've got more recent figures. 14, okay, yeah. So, and this is after over a decade of our involvement there, right? So we still have, and there's questions if you don't have a literate population when it goes to attitudes surrounding rule of law, and do people understand what law is if we don't have basic levels of literacy, which can be a marker for basic levels of education. What are the levels of poverty in a country? If people are spending a lot of time taking care of basic needs like hauling water from one place to the next, trying to make sure they have food, their families have food, are they really thinking about these big ideas which are inherently what we're talking about with rule of law? So it's something to also be considering as we're thinking about this. The third category is the level of institutional or political development. So I had a hard time finding a picture for this one, so the best I could come up with was the Failed States Index cover. So, if you've got ideas of what could illustrate this, but it was really hard to think about how to illustrate this. But what I'm thinking about in this category is how much does the government really control the country? So in Afghanistan, there's serious issues about how much the government controls the country outside of Kabul. Something like 13% of the population lives in Kabul, so a whole lot of the country doesn't. And so if the central government doesn't really control most of the country, then there's questions, right, about how effective some of this work can be. And levels of institutional development can also just mean how ready are people in these various institutions to receive various types of aid, and does it make sense? So when I was working in Albania, which is a very different level of development from Afghanistan, it's rightly in Europe. It's got very much higher literacy is not an issue, education, all these things. But one of the projects was to provide computers to prosecutors. And so one of the internationals who was involved in this went to check up and see how those computers were getting used 6 months later. They went to this regional prosecutor's office and checked in and said, so how's it going with the computers? And the head prosecutor in this office said, it's going great, let me show you. We've taken very good care of these computers. So they walked down to kind of a basement, and inside a room, that looked like it had previously been a holding cell. They unlocked the room and walked back in the must, and saw the computers all nicely stacked, being very well taken care of, right? But not being used, right? Because folks weren't ready for it. That's not how they thought about preparing their cases. They didn't think they needed computers. So it's something to be very conscious of, right? Where's the starting point? What's the level of institutional development, and where are we starting before we think about what might make sense to do? Part of this discussion is also corruption, right? How endemic is it? How does it operate? What might or might not make sense to do given the levels of corruption? So one of my concerns about importing plea bargaining to countries with high levels of corruption, plea bargaining happens behind closed doors, right? It's agreements between prosecutors and defense lawyers about what to do on a criminal case. The Republic of Georgia introduced plea bargaining a number of years ago. Georgia's a country like many that has had serious problems with corruption. And the first cases that were being plea bargained, the agreements were that the defendants pay money, and then the cases, they wouldn't have to do jail, right? They paid money and the case was over. Now, to most people in Georgia, that just looked like a court-sanctioned payoff. That didn't look like something that was under the rule of law. So we need to be cautious and consider what is the current environment, what's the levels of corruption, and what that might mean in terms of what might make sense to do or not make sense to do. And the final category is ongoing armed conflict. So this is a picture of a civilian aid worker who was going to be heading out to Afghanistan, getting training on how to handle that difficult environment. This is a lawyer who was working in Afghanistan, in her flak jacket. One of the concerns that I have with this is, first of all, lawyers, unless we're talking about lawyers in the military, are not militarily trained, right? We don't have training in how to handle ourselves in conflict environments. And so there's concerns about bringing in people who don't have the right skill set into dangerous situations. But the other piece of it, and the piece that I'm a little bit more concerned about, because I think these folks are going in with their eyes open. I mean, they're adults, they know what they're doing. My bigger concern is what's the impact of the quality of work on the ground when you have ongoing armed conflict? So you end up with private security forces, that's who these folks are, helping to secure convoys to the airport. I've got a friend who works in Iraq. I don't know if you've done work in Iraq, but apparently there's little convoys that go out to the airport, cars and armed guards still. I mean, this is just a month ago she was there. Going out to various regional centers can mean going with military assistance, which it's one thing if we're talking about civilian affairs divisions of the Army, which is a whole separate conversation, and that's not what I'm talking about. But it's another thing when we're talking about civilian lawyers going out to do rule of law development work. A lot of rule of law development work is really building relationships. It's one-on-one. It's people getting to know each other and trust each other and like each other and learn from each other. And that's very difficult to do when you're in an environment that limits how much people can do that. When people are living in armed compounds so they can't go out after at nightfall or at all, right? They can go into lockdown modes depending on what's going on with the security situation. It's difficult to have the informal coffees and chats. It's difficult to have the people being seconded directly to a ministry, say the prosecution's office or the Ministry of Justice, and doing the one-on-one daily interactions that can really make a big difference in terms of people learning and people's changes in attitudes. So I have serious concerns. I think if people need to go in and the only way they can move around is in armed convoys and it limits what they can do and where they can do it and who they can meet with, I have serious concerns about the quality of the work that can go on. And I think that we need to think very seriously about whether it's timely to do rule of law development in that kind of an environment. The bottom line here is, and leads to the question that I think some of you may be asking, well, why not include rule of law development generally? I mean, is there a problem with it? Well, I think, from my comments, it should be clear that I have questions about whether giving aid is assisting to build rule of law. I think we sometimes, but sometimes not, and I think it's unclear. I am concerned about the waste of resources, but it's not a huge amount of money when you look at our budget. I mean, foreign aid's not a huge amount of money, and rule of law is just a piece of that. So that's not the biggest concern, but it's a factor. My biggest concern, and I think Michelle may talk about this more, is the prevention of harm. I am concerned that if we're doing work that doesn't make sense to do, we may in fact be setting back the development of rule of law. I don't know that building all those courthouses in Afghanistan have helped to build people's trust in the formal legal system in Afghanistan when they walk by them and see them falling to pieces and no one using them. And that's just one example. So when I think about it, I think that there's a few other options. One, rather than just routinely including rule of law development assistance and the full standard menu of rule of law development assistance. The first is to limit the type of assistance that we're giving, to really look critically and carefully at the particular country, the individual circumstances in that particular country, and decide what makes sense in this context to do. It may not make sense to do a whole lot of work with formal legal structures, but we can focus on a few areas, like legal education or education generally, and look at what might make sense to do in those limited areas. And there's also the reality that encouraging the development of rule of law doesn't only happen in a development context. There are other ways to encourage the development of rule of law. And in particular countries, it may make better sense to work on those levels, which at a political and a diplomatic level. The organization that I worked for a number of years, the OSCE, was the successor organization to the Helsinki Accords. I'm sure a number of you remember the Helsinki Accords decided between, or agreed to between the United States, the Western Europe, and the Soviet Union. And one of the important parts of the Helsinki Accords was it included human rights as something to be talked about, to be discussed, as a legitimate area of discussion between the countries that were parties to the Helsinki Accords. And that may be the best way in some places to be talking about rule of law and better human rights protection is at that political and diplomatic level, and not bringing it to the development level just yet. And I say this because rule of law matters. It matters tremendously. And in the work that we're doing, we should be enhancing the rule of law. We shouldn't be trivializing it. And that's my concern with some of these approaches. So, Michelle, forward here.
Michelle Hughes is the founder, president, and chief executive officer of Valrac Innovation, LLC, a company dedicated to preparing the next generation to restore and strengthen the rule of law at home and abroad. Ms. Hughes' work focuses primarily on building capacity for multinational, interagency, civil, military, and public-private cooperation to build and strengthen the rule of law, resolve violent conflict, and enable sustainable peace. She is also chief of global strategy for InternetBar.org, Inc., a senior fellow with the National Defense University Joint Forces Staff College, and a senior pro-law development advisor for Loyola University Chicago School of Law. Ms. Hughes was formerly senior executive in the U.S. Department of Defense, where she was the only designated highly qualified expert for rule of law and security sector reform. She has field experience in 12 conflict countries across 4 continents and was deployed multiple times to Afghanistan, where her role was to advise senior military commanders on how to connect security force development to governance and justice. Originally from Buffalo, Ms. Hughes graduated from the University of Florida in '79, where she obtained a BA in English, was commissioned as second lieutenant in the United States Army. As a military intelligence officer, Ms. Hughes was one of the first women to serve in the elite 82nd Airborne Division, the only woman officer ever assigned to the Army's parachute demonstration team, the Golden Knights, and Golden Ladies, maybe. I'm in trouble. And the first woman to command an electronic warfare company in armored division. She was honored by President Reagan as one of the top 10 working women of 1985 and subsequently served in combat in Panama. In 1996, Ms. Hughes graduated at the top of her class from Regent University School of Law. She practiced complex civil litigation, prosecution, and criminal defense with Williams Mullen, and is admitted to the bar in Virginia and District of Columbia. Michelle.
Well, thank you, Craig, for the great introduction. It's really, really difficult for me to call Professor Stern Craig. I had him for 3 classes when I was here at Regent, my 3 most difficult classes, including conflicts of law and Fed courts. But I like to say to many people that it was those classes and struggling with the issues of how do you look at jurisdictional issues and make good choices that actually have made me the rule of law practitioner that I am today, with the ability to go into countries that have different legal systems from our own, and particularly those in Islamic systems and hybrid systems. And so I really appreciate that. Many familiar faces out here, and it's a pleasure for me to be speaking at my alma mater, Regent University School of Law. When I came back from Afghanistan at the end of 2011, the first thing I did was I called Dean Brauch and I said, you know, I'm not sure if you're aware of this, but over the last 12 months in Afghanistan, Regent graduates have been heavily influencing the development of the Afghan National Police toward a police force operating within the rule of law. I was the senior rule of law advisor for the NATO Police Development Mission, and Christiane Burrell, another Regent grad, was legal counsel for the European Police Development Mission. And we were there at the same time, and it was actually pretty exciting. So I'm so happy to be here today. And I do have experience in East Africa. I've worked in, and West Africa as well. I've worked in Liberia, Ghana, Yemen, Djibouti, Kenya, and Ethiopia. since probably about the mid-2000s. And when I went to Afghanistan and started working there in 2009 and beyond, and all the way up until this past month when I was back on a special study for the U.S. Institute for Peace, I took those lessons from my work in Africa, and I felt that they were directly applicable to the conditions on the ground. So today, while I'm going to talk about a lot of different countries, perhaps, I just want you to know I'm talking about things that are common across all conflict environments, and working in conflict really is my specialty. I'd like to start off, because I am a development practitioner, I want to start off with the problem of perspective and the importance of empathy, because I think it's absolutely critical when we begin to talk about restoring or strengthening the rule of law in other jurisdictions than our own, that we try to put ourselves in their shoes, and this is an extremely difficult thing to do. So let me start by asking you a few questions. How many people in this room have ever tried to track a criminal case in the U.S. from complaint to arrest, through prosecution, appeal, incarceration, and release and reintegration into the community? One person. How many people have ever tried to do this in a foreign country? How many people have ever been the victim of a crime or had a child who was the victim of a crime? How many people have ever been arrested or had a child or relative you were legally responsible for who was arrested? How many of you have ever been inside a prison? How many of you have ever been inside a prison in a third world country? How many have been a party, not a lawyer, but a party to a civil lawsuit? One person, two people. If you're a lawyer, what percentage of your cases do you settle or plead out outside of court? Just think about that. Have you ever been unhappy with or flat out disagreed with the decision of a judge or a prosecutor or a cop who decided not to pursue your case or complaint? Have you ever been involved in the lawmaking process in the U.S.? Thanks to one of my former professors here, I was involved in a rewrite of a provision of the Uniform Commercial Code. It was just a nightmare, a 3-year experience from which I haven't recovered. Have you ever practiced law in any other legal system besides our own? And how much time have you ever spent on the ground riding around or walking around with police officers on duty? And have you ever tried to go down to a police station to file a criminal complaint? I think it's really important to step back and sort of look at those experiences from a very personal level. I believe rule of law is fundamental, and it is in our hearts. It is fundamental because it deals with issues of peace and justice and reconciliation. And I do believe what Pope John Paul II said, which is if you want peace, you have to work for justice. This is written on our hearts. And everywhere we go, people are looking for fundamental fairness, they're looking for justice, and they want peace. And so when you think about these questions that I was just asking from an experiential standpoint, it's very important to remember that each of these experiences have a different impact depending on where you sit. From the perspective of someone who is in that system, the victim, the complainant. From the perspective of someone who's a government official who's in that system, the cop, the prosecutor, the border guard, a local governance official on a community council, and then there's the perspective of the outsider who is in there to help. And quite honestly, my experience is that most people who go into these countries, in fact, almost all of them are there because they want to help. But very rarely do they step back and really start looking at what the cultural context is in which they are operating, what the legal context is in which they're operating, and what is the experience of those individuals who are part of that system. And ultimately, when you look at those different perspectives, each perspective leads to a very different set of conclusions about whether the rule of law system is working or not, whether it's legitimate or not, and ultimately whether the government itself is both legitimate and effective in the place and where you are. And this is only the beginning of the rule of law development challenge. When you add in the problem of ethnic, tribal, and religious fault lines that cut across the civil and administrative boundaries in East Africa, which do not parallel those lines, you've now exponentially increased the complexity of the problem and the challenges in advancing the rule of law in a region like East Africa. And it's very important to keep that in mind. Cynthia talked about rule of law definitions. And if you're starting to get, I hope you're starting to get the idea that from my perspective, the best rule of law definition is one that really places rule of law squarely in the governance context. I use in my work the UN definition from 2004 that says that rule of law is a principle of governance, and it goes on to talk about accountability to the law, talks about human rights, talks about a number of issues. But at the end of the day, I have always broken it down that rule of law is about accountability of the government to the people to legitimately empowered government, and both to the law itself. The law then becomes merely a tool for codifying the rules of the road, if you will, within that framework. And to achieve the rule of law, you have to address it as a governance problem, not as a set of technical problems. And it has to be within the context of the culture and the grievances of the society that that particular government serves. Now, I was asked to talk about a lot of things this morning, a whole lot of things, including the intersection between security, justice, and governance, which is something that I have lived and breathed for more than 30 years. So I want to talk about addressing this governance challenge generally. By starting out with, it requires that we have enough security to provide governance space. A lot of rule of law practitioners are very uncomfortable with the security issues that are involved with rule of law. But the bottom line is you can't have accountable governance and you can't have processes that work unless you have enough security for them to function. So for instance, when I was working in Liberia, I really saw one of the better examples of how to make this happen in a very deliberative way. One of the issues, of course, in the Liberian Civil War, amongst many, many others, was the problem of natural resource exploitation. And Liberia, like Sierra Leone and like so many countries, had this problem of blood diamonds and also illicit lumber trade and illicit power structures get involved in these operations because they're very, very profitable, and it creates the rise of mafias, for want of a better word, that then gradually begin to take over that space, and the government loses control. And you see this in so many resource-rich countries. It's the resource curse. And in Liberia, when the UN mission in Liberia, UNMIL, went in to try to help the government of Ellen Sirleaf Johnson to retake control, one of the things they had to do is they had to regain control over these resource-rich areas, which coincidentally were areas where former combatants had holed up and had not been successfully reintegrated yet. And so this is how they did it. They started out by sending in a Nigerian infantry brigade to clear the area from a military standpoint. This was followed up by a formed police unit. Formed police units are really civil order police units that have the capability to go in they generally do not, at least doctrinally, they do not use military force, they use non-lethal force, but in a very effective and frankly sometimes lethal method or lethal way. But they sent in formed police units to then create a stability cordon. And once that stability cordon was created, or that boundary was created around a resource-rich area, at that point you could bring in the Liberian National Police, which was a very nascent police force that was being supported and stood up by UNMIL. Only once that police presence was established could they begin to restore the government leaders to that space. And those security cordons, local police, stability police, and military boundary, had to stay in place long enough for the government to be able to reassert its control and all of the effective government functions, to include dispute resolution processes, in order to maintain and retake control and create some stability in those regions, and then be able to manage those resources once again. And this is a long and hard process. And what it really requires is, it requires this very complex negotiation between security actors, governance actors, and justice actors in order to make this happen. But what I also think is important about this is it kind of points up to the importance of us as rule of law practitioners not forgetting security forces when we start to look at rule of law systems. Because in order for the security forces to act correctly and accountably, it requires governance oversight, and this is also where the judiciary comes back in. Because then they begin to interpret the security laws and they begin to adjudicate those times when security forces get out of control, and they begin to establish a culture of accountability within security forces themselves. And as we look at what's happening in Ukraine this week, for example, I'm reminded of what my French gendarmerie deputy told me in Afghanistan when we were working with the civil order police. He said, you know, the important thing about riot police in particular is they have to remember that they're doing two things. They're reestablishing the control of the government, very important, but they also have to do it in a way that protects the right and the voice of the protesters. And this is a very nuanced capability. And it's one of those areas where security forces become absolutely key to protecting the voice of the people and protecting the ability of the government to control the space and enable the rule of law to thrive and exist. And so I think it's critical that we don't forget this. I've mentioned the word grievances quite a lot, and you know, I want to talk for a moment about that again, because this goes to the governance challenge. And to address grievances, you have to have legitimate dispute resolution systems. These are not always formal. In fact, most of the time they are informal, particularly when we're operating in Africa. But that doesn't mean they're outside of government control or recognition. And so there have to be government processes to legitimize those systems and to make sure that they're in consonance with the basic underlying values of the legal system in which you're working. And then, again, the government has to have the ability to safely and securely protect those processes and then enforce those judgments. And we forget about the importance of enforcing judgments. So oversimplifying this very complex problem, I hope that you're kind of beginning to see this triad of governance, justice, and security, all of which have to work in consonance with one another if we're going to achieve even a moderately functional system within the rule of law. So with that, I was asked to talk about what works, basically. I'm paraphrasing slightly, but I'd like to put this in terms of what works and why does it work, and what do we know? So first of all, we know that to effect any degree of lasting change, we have to address the governance, justice, and security triad as a whole. This is what's known as the comprehensive approach, and the Organization for Economic Cooperation and Development has done a lot of work on this starting in about 2004. They began to try to codify some of the lessons out of the conflict of Sierra Leone, which had gone on, which had had 3 iterations of international intervention in an attempt to stop it. And ultimately, it wasn't until the British reached back into their colonial past and started to pull in some of their best practices for comprehensive administration that they started to really deal with the difficulty of how do you neutralize all of the different power structures that were stoking conflict in that environment, and then how do you restore good governance? And the work that came out of that jump-started this effort by the Organization for Economic Cooperation and Development to codify best practices worldwide, but principally with a focus on what had worked and what hadn't worked in Africa. They also drew very heavily on the truth and reconciliation processes out of South Africa. And this is codified in a manual. It's online. It's the OECD Handbook for Security System Reform. And although it is, a consensus-based document, which means a lot of compromises were made and recommendations, the fact is it does capture the principles of a comprehensive approach very well. And in those places where we've had the commitment and the unity of action as a donor community to a comprehensive approach that was host nation-led and host nation-owned, both at the national level and at the local level, we have in fact seen success. And where we haven't put that practice into play, where we persisted in stovepipe technical solutions across courts, cops, corrections, legal reform, civil society, and special interest areas, we have not had real sustainable success. Because at the end of the day, governance, justice, and security are inextricably linked. And those linkages have to be understood, and the dependencies have to be addressed. The second thing that we know is we know that governing, adjudication, and security functions are power positions. So wherever the balance of power shifts, it gives rise to spoilers, it creates opponents, and it upsets existing power sharing agreements. And these are both formal power sharing agreements and these are informal power sharing agreements. And it doesn't matter where you operate, you're going to see that interplay. You see that in our own political system here. When we're operating in places like Africa, these informal power structures are absolutely critical because the central governments don't have a lot of reach at the subnational level for just a host of reasons, not the least of which is the absence of infrastructure. Remember in Ethiopia, for example, the difficulty of getting from Addis Ababa to other parts of the country was just incredible. I mean, it would take literally days to get from the capital out to some of the major border regions where conflict issues were needing to resolve or be resolved. When I was in Liberia, we were completely dependent during the rainy season on UNMIL helicopters to move us around. Because during the rainy season, the roads, once you left Monrovia, became non-existent. They were just sheets of mud, rivers of mud. And so if you don't have this capacity, you've got to question, well, how strong is the reach of the government? And I remember meeting with police officers out in the Liberian substations in the border areas on the Guinean border and in Cote d'Ivoire, and they hadn't been paid in 3 months. Not because the pay wasn't waiting for them. There was no mechanism to actually get their pay out to them. There was no mechanism to get cell phones out to them. They were using their personal cell phones to do government business at major border crossing points. And this is a real problem, but it exists, and you have to work within that framework. So understanding the importance of informal and subnational power structures and the impact then that reform efforts have on these power players is key because it requires that you go through a risk assessment and a risk mitigation process before you go in and try to change anything. And there needs to be a good risk mitigation strategy for everything we do because there will be new grievances and there will be threats to peace. So how are you going to manage that problem? The third thing is we know that change has to be seen as legitimate, and both the people and the change agents within the government must be vested in the successful outcome. This means that development activities have to be locally owned, and they have to be culturally appropriate. And I'd like to give an example from actually my experience working with the extractive industries, because I used to work with a lot of oil and gas companies and as well as some manufacturers who were operating in high-risk areas when I was in private practice. And one of the big concerns that some of the oil companies had as they were putting in pipelines and other critical infrastructure was how do you secure all of that? And when disputes arise at a very local level in some of these places like Nigeria or Azerbaijan or places where the ability of the government to enforce the public-private partnership agreements that existed between the oil companies and the national governments, when the government doesn't have that reach down at a local level, how do you enforce your commercial contracts? And one of the best ways that we found was to start working with local government and security leaders on the ground in some of the villages where these pipelines and critical infrastructure were passing through or were located. And we began to work with some of the local governments on things like some basic human rights issues and education issues, and really, and community development, and put some of these private companies in the extractive industry in the position where they themselves became development actors at a very low level. And at that point, when these activities were responsive to what the community elders were seeing as their most critical needs, the community as a whole became vested in the security of the commercial operation. And it really mitigated the risk, and it meant that you had an entire community's worth of eyes on these pipelines. And it really mitigated the security risk, and it protected investment, and it encouraged more investment. And it also really brought the locals into the process of, just the extraction activities themselves. And so people began to get educated on the commercial side of this, and it became part of the commercial fabric of the community. Very important. This is successful development. And you have to look for creative solutions like this, but this requires a lot of collaboration, and it requires stepping back and taking on that characteristic of true empathy, where you really are trying to put yourselves in the shoes of the people that you're working with. And this is hard to do because it's not quick, it's not easily measurable, it's not usually assessed, and it's not, frankly, rewarded. We know that faith-based solutions tend to work very well in rule of law development, with a caveat. They tend to work well if they are ecumenical and inclusive. When they're not, they become drivers of conflict. And I was always very impressed in my work in Africa with the Catholic Church in particular, because everywhere I seemed to go, I would see the Catholic Church, I would see the priests in partnership with the imams and the pastors working on community reconciliation projects. And also speaking out from their pulpits in their homilies against government corruption. And because they were doing this in partnership with other religious leaders, there was a legitimacy to it regardless of the community audience. And they were able to get some very powerful messages across. At the same time, I saw churches with rule of law development efforts and peace and reconciliation efforts that were really no more than just conversion efforts. And there's nothing wrong with that. If you're going to go in with a conversion mandate and an evangelical mandate, that's great. Just be honest about it. You can't go in there and make that your rule of law development activity or your peace and reconciliation activity, because other people who don't believe in that particular faith-based philosophy, if you will, for want of a better term, but who are people of belief, they all think God is on their side. And so all you're really doing is just creating more conflict, more grievances, reinforcing old grievances, and reinforcing those religious fault lines that have existed long before many of the administrative boundaries, governmental administrative boundaries are put into place. And so this requires a very deft hand. The other thing I like about faith-based solutions, and these have been really key, by the way, to the truth and reconciliation processes in South Africa, but the other thing I really like about them is that when we're coming out of conflict, the reintegration process for former combatants or former gang members or former criminals is really emotionally fraught. And I worked with a guy who used to do gang reintegration in Latin America, and he coined a phrase that I have used ever since. I love this. He called it reconciliation space. And he said, when you're trying to bring people in from from these very powerful organizations, they have done terrible, horrible things. And not only do you have to break them away from the organization from a security standpoint and just from a physical standpoint, but you have to create the space for them to come to terms with what they have done. And until you do that, you cannot have true reconciliation within the communities. I think this is a really powerful thought. And for us as, people of faith, and for Regent as a Christian law school, I think this is one of those areas that we really need to look at very hard. And there hasn't been a lot of study on it, but I can tell you just anecdotally, I have seen this work. What I am wary of, and I'll echo Cynthia on this, and she hit these pretty hard, I'm wary of legal reform, technology, and buildings and infrastructure, which are all easy fixes. Legal reform, I particularly have a very jaundiced view of. And I love that you brought up Afghanistan, because the law was very difficult to find in Afghanistan. But in fact, the more we've discovered, the more we've looked, the more we've discovered that they have about 100 years worth of law on the books there. And last month, when I was in Afghanistan, I had a day where I got to go play tourist in Kabul. It was after the attack on the internationals at the Lebanese restaurant in what was considered to be a safe zone. Everything shut down after that day. All of my meetings got canceled. I was out in a guest house in town, and so I hired a guard and a driver and went out to see some of the tourist sites in Kabul, which I had not gotten to do a lot of when I was deployed there, although I had gotten to do some. And one of the places I went to was the National Archives. Who knew? I had no idea. I thought I was going to the art museum. And what I found in the National Archives was they had 100 years worth of legal documents. They had exemplary property settlements, divorce settlements, marriage agreements, dower transfers, commercial transfers, indentured servant agreements, agricultural sales agreements, land use agreements, ordinances, regulations, and they had these things all recorded. And they were all sitting in the archives, laid out, beautifully curated with the help of the Germans, all translated into German, by the way, not very helpful. But, there they were. And I looked at this and I thought, holy crap, I've been working in this country for 4 years. I've been listening to all of the rule of law experts that are working here saying that the Afghans need help with their laws. And there it all was, sitting in their own national archives. And I have yet to meet a person in the international community, by the way, that even knew that the archives existed. So, we need to be careful. So I think with that, I'm about out of time. But again, thank you for giving me the opportunity to speak today. This is just a real privilege, and what a great idea for a conference. So I'm happy to take questions, and I'll be around definitely all morning and through lunch, and I'm looking forward to engaging with all of you during the breaks.
Are we to end at about now? Well, and by the way, I'm glad you said holy crap and not just crap. This is a Christian school.
Yeah.
Cynthia, would you like to respond to Michelle?
No, I think if there's questions.
Yes, maybe we can take a question perhaps or two. Yes, please.
I have a question for Ms. Hughes. I was just wondering how you can work within a Sharia law system.
Okay, I think this is gone. All right, well, that's one of my favorite questions, quite honestly. The question was, how can you work effectively within a Sharia law system? And this kind of goes back to, I said how many people here have ever worked in a legal system other than their own. My experiences, and I've worked in a lot of systems now, first of all, in almost all developing countries, you're going to find a hybrid legal system. It's going to be a combination of civil or common law, depending on who the colonial power was there. customary law, and religious law. And there can be a mix in that. And what I've always found is in every legal system, to include Islamic law, when you really boil it down and look at the fundamentals of the system, the elements are almost always the same. There's always a way to deal with the issue of property rights and property ownership, commercial transactions, domestic disputes, marriage, bad marriage, inheritance, all of these things that are, grievances, injuries, all of these, reconciliation, retribution, all of these things are common to every single system. And it's very easy to put labels on legal systems and say, oh, well, Sharia is bad, or the civil law system isn't as effective, or customary law is not going to work well. But when you really start stepping back and assessing it and looking at it in practice, the fundamental values are the same, the components are the same, and it's very, very important to work within that context. And I'm really reminded when I was in Afghanistan, I worked with which is a hybrid system of civil law, customary law, and Islamic law in a Hanafi school of thought, which is way different than Iraq, for example. But in Afghanistan, I was working with a district community council down in one of the most contested areas in the country, down in Sangin district in Helmand province, where we and the British have literally lost hundreds of troops and remains very heavily contested today. It's a traditional Pashtun area, and it's also rife with transnational organized crime because it's kind of on a crossroads between many of the trafficking routes coming out of Pakistan and heading up through Kabul. And down there, the District Community Council established a justice subcommittee, and that justice subcommittee decided that they needed to define the rule of law for themselves and for the district. And the definition they came up with went something like this. It was, the rule of law is man's imperfect effort to implement the will of Allah on earth. It requires that we treat every person fairly, and that we make sure that every person believes that they are being treated fairly under the law. And there was one other element to it, but ultimately what it boiled down to was the same thing that we talk about here, and that we talked about here, in our common law class when I was a student at Regent, which was, our imperfect attempt to implement God's will here on earth, and to do it with fairness, with fundamental fairness and justice for all. And their interpretation under their system was absolutely no different from what we used to discuss and debate. And that was a real lesson for me. And so I think that we have to step back and we have to be very humble when we start looking at systems. And we have to look for the common ground as opposed to looking for the differences, and then figure out where those differences exist. Are they differences that we can't live with? Are they abusive? Are they oppressive? Or are they differences that are difference in process, and maybe just where does it come from? And those things we can work through. Those things we can come to consensus and common agreement on, and when we do, we tend to create some really excellent opportunities for very meaningful interaction and really meaningful values discussions as they look at their own system and look at the reforms that are necessary to take place within it.